So what we learned previously, we were actually able to define who is a director. So we are actually able to define who is a director of a company. Apart from that, we are actually able to look at the appointments and qualifications, we also looked at the disqualification from office, how it can happen. How can it happen with regard to disqualification from office? We also looked at the duties of a director, So I think we had covered almost up to this particular point. So we also looked at the mandate of the directors, the mandate of the directors. So I would like us to basically focus on another new things, like, for example, loans to directors. We have what we call remuneration of a director. Then you can look at compensation for loss of office, Then lastly, we can be able to look at something known as insider dealing. Then maybe we can look at register of directors. So we looked at the appointment, how it actually happens. I don't want to repeat more about that. So I think you basically understood. Disqualification, duties of a director, whereby we talked about we can be able to have what we call fiduciary duties of what we call care, skill, and diligence, duty to promote the success of the company, duty to act within the powers given to them as directors of the company, not to act ultra vires. So those were some of the duties that we actually looked at. So and we looked at the mandate of directors. We simply say that once the directors have actually been appointed, it simply means that they have been given all the powers under the articles and also under the statute to be able to perform these particular duties and powers given under those particular documents. So the members shouldn't actually interfere with basically how they are managing the company. But we looked at some exceptional circumstances under which members can actually be able to intervene. So for example, we said in case these directors cannot be able to work together. So there's what we call deadlock in management. Members can actually be able to intervene and appoint other persons to serve as directors. Alternatively, we also say that, or in another way, we said members can actually also be able to intervene in case, for example, these directors are basically using the name of the company in what we call litigations or court litigations without having been approved by the members at a general meeting. Also, we said if the directors actually act beyond the powers given or act ultra vires. So as I told you, ultra vires basically means acting outside the requirements of either the memorandum or articles of association, because these powers of directors will be outlined in the articles. So if they act beyond those powers given in the articles, we simply say directors are acting ultra vires. So if they act ultra vires, members have a right to be able to intervene and actually basically look at what these particular directors are actually able to doing in the company. So maybe they can evict them or basically appoint other persons to serve as directors of the company. So loans to directors. So basically, I would like us to look at this particular area known as loans to directors. So what you should actually be able to gather is that generally the issue of loans to directors is prohibited under the statute or under the Companies Act. So that is what we are saying. Loans to directors generally is actually prohibited. Directors are actually basically prohibited from actually getting or acquiring loans from the company. So unless maybe this particular loan has actually been approved by the members at a general meeting. So that is what we are saying with regard to loans to directors. Generally, the issue of loans to directors is prohibited under the statute or under the Companies Act. But of course, it can only happen in case, for example, it has actually been approved by the members at a general meeting. So under certain circumstances, you might find that a director is actually able to get a loan from the company. So the exceptions to this particular provision, whereby now a director can be able to get a loan, exceptions to the prohibition exception to the prohibition of acquiring a loan from the company, acquiring a loan from the company. So under what circumstances can the director actually be able to get a loan from the company? So number one is if the company is a private company. So for private companies, there is no prohibition. So for the case of private companies, the director can actually be able to get a loan from the company. So that is what we are saying. If in the meantime, the company is a private company. So if the company is a private company, so in such a case, the director will actually be able to get a loan from that particular private company. But if it is a public company, 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 we are saying that it is prohibited. So the loan cannot actually be acquired unless it has been approved by the members at a general meeting. So another exceptional circumstance whereby the loan can be given, if the ordinary business of the company is to give out loans, if the ordinary business of the company is to give out loans, or lend money. In such a case, there's no actually prohibition for basically stopping the company from actually giving a loan to a director, giving a loan to a director. So if, for example, it is a bank, you know, the most obvious business of a bank is giving out loans. So you can't prohibit the bank from giving out a loan to a director. And of course, that is business for them. Because when the director pays for this particular loan, he'll basically pay with some form of interest, which is basically business for the bank. So if the ordinary business of the company is to give out loans or lend money, under that particular exceptional circumstance, then in such a case, the company can actually be able to give a loan. Another one, let's say number 3, the exceptional circumstance under which a loan can be given to a director. So if the loan is to facilitate, the functioning of the office of the director, the functioning of the office of the director, So in this case, for example, there could be a knowledge gap in that particular office, or basically the holder of the office has a particular knowledge gap. So they can actually be able to finance this particular director to go abroad and actually basically maybe undertake certain studies so that he can bring in the expertise in the company. So long as the loan is basically to facilitate the functioning or proper functioning of the office of the director, under that particular circumstance, then the loan can actually be given so long as it has been approved by the members at a general meeting, So another one that you can actually be able to maybe give, or maybe number 4, you can simply say, if the loan is approved, by the members at a general meeting, where the reasons for the loan have been given, where the reasons for the loan have been given, the reasons for the loan have been given, where the reasons for the loan have been given, where the reasons as to why the loan is being taken has actually been given, so long as it has been approved by the members at a general meeting of the company. Then if proper reasons have actually been given, then the loan can actually be given to the director. So, but you've said generally, the issue of loans to directors is actually prohibited. It is actually prohibited. It is prohibited. It is prohibited. So the issue of loans to directors is actually prohibited. It is actually prohibited. So if the loan is approved by the members at a general meeting where the reasons for the loan have been given, then we've said another one is if the loan is to facilitate the functioning of the office of the director. Then we've said another one, if the company is a private company. So in such a case, if in the meantime the company is a private company, then under such a particular circumstance, the directors are not actually prohibited to acquire loans from the company. So what we mean basically in private companies, the director can actually be able to get a loan, but not actually in public companies. So if it is in public companies, so other things have to come in. For example, there could be a must that there is a general meeting before the loan can actually be approved. If the ordinary business of the company is to give out loans or lending of money, also under such a particular circumstance, the directors won't actually be prohibited from actually getting a loan from the company, So that is basically what you need to be able to know about loans to directors. So the most obvious question that has been tested there is just what we've just gone through, those reasons. So they could ask, what are the exceptional circumstances under which a director can acquire a loan from a company? So just remember those particular 4 points the teacher has just gone through. So it has been tested previously. So we can look at remuneration of a director. What happens with regard to remuneration of a director? So what we mean by this is basically salaries or basically allowances. So what basically happens with regard to remuneration of a director? So the first point that should actually you should go home with, the first point that you should actually basically carry home with you under this particular point of remuneration of directors is that there is no provision under the Companies Act or under the statute that a director of a company must be remunerated. That is a point you should actually be able to carry home with you, that there is no provision under the Companies Act or under the statute that a director of a company must be given a salary or be remunerated. So there's no such kind of a provision under the Companies Act. So after that, basically what you need to know, however, each and every company's articles of association will basically outline how the directors of the company will be remunerated. So you said up there, under the Companies Act, you won't find any provision that basically requires if you are a director of a company, you be remunerated. But when you come to each and every company's articles of association or rules governing the internal affairs, those articles will basically give guidelines as to how the director of a company will be remunerated. So that's why basically if you go to different types of companies or different companies, company XYZ, you go to ABC, you'll find that basically directors are remunerated differently. So a director at maybe KCB, a director at Safaricom, they'll be remunerated differently as per the rules that have been given or rules that are guiding remuneration under the articles of association of that particular company. If there are allowances, you'll find that in these particular companies, they get different allowances. If you go to the other one, they get different allowances. So we are saying basically what you need to know is that no provision under the Companies Act that a director of a company should be remunerated. However, under each and every company's articles of association, basically those rules will be able to give guidelines as to how a director of that particular company can be remunerated. So once that has been provided for under the articles, if the company fails to remunerate or pay a director, that director has a right to recover that particular liability by simply suing the company. So it becomes a liability. Once you've basically stated that on the appointment of this particular director, as a company, you're going to pay the director this particular amount of money. Failure to pay that particular amount, basically it means that the director can actually be able to recover the amount by simply suing the company to pay all the debts or all the liabilities with regard to his remuneration. So it is a must that the company should actually be able to pay so long as they have been able to indicate under the articles as to how much the director should actually be paid as a salary or remuneration. So that is basically what you need to be able to know about remuneration of directors. So I want us to look at another one, compensation for loss of office. 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 So this simply means that you compensate the director in case he has actually lost office. So if a director loses an office unfairly, so under unfair circumstances, this director should actually be compensated. For example, if it was actually a contract for 5 years, he has been able to maybe serve for only 3 years. So there are 2 years that are basically remaining on that particular contract. You need to basically agree with the director as to basically how you'll be able to compensate for the 2 years remaining on the contract. So it simply basically means that it will be the agreement between the director and of course the company as to how those particular 2 years remaining on the contract will actually be compensated. But we've said if the director loses the office unfairly. What we mean by this, under certain circumstances, you might find that this particular director has lost office unfairly. For example, what we mean by this, we can give examples under what circumstances he can be compensated. For example, in the case where the company is amalgamating or basically merging with another company, then it basically means that this particular director might lose office. What we mean by this is that NIC Bank and Commercial Bank of Africa. So in the NIC Bank, we have 8 directors. In Commercial Bank of Africa, we have 12 directors. After the merger, these particular 2 companies become NCBA. Do they require 20 directors? No, they don't require 20 directors. Maybe they'll just require, let's say, for example, 14 directors. What do you realize? 6 of them are basically going to lose office. So what you need to be able to do in this case, it simply means that you have to basically compensate the 6 of them if basically their term had not actually come to an end at NIC Bank and Commercial Bank of Africa. So what we mean by this, directors have a right to be compensated in case they have actually lost office unfairly. But basically, if they have been disqualified, for example, if this particular director has been disqualified, for example, if it is found that this director cannot serve as a director due to maybe certain reasons, maybe he has been involved in fraudulent cases, he has been declared to be bankrupt, this director has been declared maybe to be insane by a competent doctor. So under those particular circumstances, it simply means that there's no way the company will actually be able to compensate. For example, he has actually been disqualified to continue to serve as a director of the company. But of course, if he has lost office unfairly, it simply means that the company has to compensate this particular director. So I just gave an example. For example, in the case where the company is to merge with another company and the office of that particular director simply means that it is no longer needed. So due to, for example, things like, for example, change of management, so the company is basically restructuring, so they don't want to basically have so many offices or maybe departments. Due to the restructuring, the director loses office. The company has to ensure they agree as to how they'll be able to compensate that director for having lost office. So that is what you need to be able to know about compensation for loss of office. Compensation for loss of office. Compensation for loss of office. So I want us to look at insider dealing or insider trading. So there's another small heading. Insider dealing or insider trading. Insider dealing or insider is sometimes known as insider trading. Insider trading. Insider trading. What do we mean by insider dealing or insider trading? It is where a person takes advantage of material information which is not available to the public to sell or buy more of shares of the company. So that is what we mean by insider dealing. It is where a person uses or basically takes advantage of material information which is not available to the public to either buy or sell more of shares of a company. So it is where a person takes advantage of material information about a company to either sell or basically buy more of the shares of the company. So I hope you've gotten that point. It is simply where a person takes advantage of material information not available to the public to buy or sell more of shares of a company. So it is where a person takes advantage of material information not available to the public to buy or sell more of the shares of the company. So what we mean by material information is that inside the company, there could be certain information which is not actually available to the public. But this information basically is likely to affect the prices of the shares of the company. That is what we call material. It is material. It is affecting. So I think maybe you've learned about the materiality concept in financial accounting, maybe in auditing. So those doing auditing, you've basically been taught about something about materiality. Basically, for example, when you're basically having to look at the information of the company in terms of how you can be able to assess it. Is that information actually material? Is it relevant for you to be able to carry out the audit? So what we mean by this material information in this case, that information, it is likely to affect the prices of the shares. For example, if it became public, or basically if the announcement was actually made public. So in short, what I mean, just today, let's say, for example, a company like Safaricom, they simply make a major announcement today at 9 p.m. that the chief executive officer, Ndegwa, has actually been sacked. Look at the prices of Safaricom the next day in the morning. Probably the prices would have actually fallen. If it was actually basically 12 shillings, you will see the shares are actually basically going at maybe 11 or 10 shillings on the stock exchange. Another thing, let's say, for example, Safaricom as a company, apart from their main product, we know M-Pesa, they have come up with also another major product, and they make the announcement today at 9 p.m. that they'll be having or basically onboarding a new product, which is basically very useful to the members of the public. Look at the price of the shares of Safaricom the next day. The prices are likely to go up. If the shares were going at 12 shillings, look at the stock exchange the next day, the shares will be going for 13 shillings or 14 shillings. Because that information that has actually basically been released to the members of the public, it is very material. And of course, Safaricom, if it has discovered a new product, it is going to become a very valuable company. If basically they make the announcement of the sacking of the CEO, probably people will actually basically interpret there's no stability at Safaricom. Why would they actually sack a basically performing CEO just abruptly? So basically the price of the shares are likely to go down. So what we mean by inside information is that this information is not actually basically public. For example, there's an insider at Safaricom who already knows this announcement will be made today at 9 p.m. So what he does, basically, he knows this is actually negative information that is likely to basically make the shares actually go down. So what he'll do, if he's actually a clever guy who is actually an insider, he'll basically simply sell off all his shares. Because if he waits for the announcement, basically it simply means that the value of his shares the next day would have actually fallen. On the other hand, for example, if we have an insider who is actually inside the company, he knows Safaricom is basically going to make a major announcement about introducing a new product in the market that has not actually been there. So he knows if this one is actually basically announced, the shares of this particular company are likely to go up. So what will he do? He'll simply basically buy more shares. So you can basically assume, for example, if these shares were going at 12 shillings, then after the announcement, they go for 14 shillings. If you had 2 million shares in the company, 2 million shares in the company, it simply means that each and every share will basically gain by 2 shillings. You'll simply basically make a kill out of it. 4 million within a day. 4 million within a day. So that's what we mean by inside information that is actually very material. If you do that, what I've just explained, we'll say you are being involved in what we call insider dealing or insider trading. So after you've understood that, basically what you also need to be able to know is that insider dealing is actually regulated by what we call the Capital Markets Authority Act. And of course, this particular act prohibits such actions. So it is actually a crime to be involved in what we call insider dealing. So it is basically a crime. It is a criminal act to be involved in what we call insider dealing. Because this information, basically, it is actually for people actually inside the company. So they take advantage of it. So those who basically can actually be involved in such, it normally leads to basically maybe the company becoming sometimes unstable. So maybe they sell off all their shares and actually exit the company. So it basically affects the stability of the company. So that's why it is regulated by the Capital Markets Authority Act and is actually prohibited. If a person is basically found to be involved in such, it is a criminal offense. And of course, the penalty or the fine could actually go up to maybe 2.5 million if you're actually found to be involved in what we call insider dealing or insider trading. If it is actually basically a corporate company, they could actually charge a fine of up to maybe 2.5 million if you are found to be involved in what we call insider dealing or insider trading. So just understand what is insider dealing, as I've explained. Also know there's that particular aspect of material information. You need to know what is actually material information. I've just given an example, for example, discovery of a new product. I've given an example, for example, announcement of change of management of the company. For example, it could be basically things to do with maybe restructuring or merging with another company. So if such things are actually happening in the company, that is material information that is actually likely to affect the prices of the shares of the company. So who are the persons? Who are the persons? Who are the persons who can be involved in insider dealing? They are simply insiders. They are simply insiders. Who are insiders? Insiders are, for example, number one, directors. Number two, employees. Number three, professionals dealing with the company. These are like auditors, professionals dealing with the company. Then number four, relatives of directors. You can talk about relatives of directors, employees, or professionals. So this one can be tested. So they could ask such a simple question. Don't forget about it. Simply insiders. Then they put there maybe 3 marks or 4 marks. State persons who can be involved in insider trading. So maybe they could ask the first one, Roman 1, define insider dealing or insider trading. Roman 2, who are the persons who can be involved in insider dealing or insider trading? So you simply say directors, employees, professionals dealing with the company, for example, auditors, any expert dealing with the company, relatives of these particular parties. Relatives of these particular parties can be involved in what we call insider dealing or insider trading. Trading. So the last thing I want us to look at is what we call register of directors.
I have a question, sir.
Yes, you can ask.
So are these people supposed to know this information and not sell their shares, like the directors or employees? You know that it's about to be given a bad information to the public and it will affect the prices of the shares, but you're not supposed to sell your shares.
What we mean by this, before the announcement or before the information becomes public, if basically it can be discovered that you simply sold the shares as a result of that information that was to become public, it will be concluded you've been involved in insider dealing. But after the announcement, there is no problem. After the announcement, there is no problem. After that particular information becoming public, the thing here is the information is actually material and it has not become public. Public means they have made announcements all over, so people know. So for example, if it is after that 9 p.m., then the next day, basically you sell the shares or you do anything with the shares, no problem. But if it can be discovered that you had that information, if they carry out investigations, investigators will actually be involved from the criminal investigation department to be able to carry out investigations. They find out whether basically this was actually insider dealing or not. So once those particular investigations actually conclude, you basically sold or bought these shares as a result of that particular information that was to become public. So it is for them to basically carry out the investigation and determine whether it was actually insider dealing. But of course, after the announcement, you do anything with the shares, if you are a director, nothing can actually basically be concluded that you are actually involved in insider dealing. So it doesn't actually prohibit you to buy or sell the shares, after the announcement. But if you are basically involved in such just before that particular information becoming public. So if they basically, for example, when we talk about they are basically accused of insider dealing, there must actually basically be the provision of the evidence. And of course, the evidence basically, we are saying these particular investigations will be carried out by people from maybe the criminal investigations department, because we are saying it is a criminal offense. It is a criminal offense. So they carry out the investigations. If they determine that you basically bought or sold these shares due to this particular material information that was to become public, yet it was not actually available in the public, you either, for example, sold all your shares or basically bought more shares in the company to take advantage of that, then basically once they conclude that, you can actually basically be penalized or actually fined. So that is basically what we mean by insider dealing. So we can look at the register of directors, So why this is actually important? It is sometimes it has led to a fall, or basically certain companies dwindling. The most famous one I can remember that it was claimed it happened, it is actually Uchumi. Uchumi was actually a very famous company some time back. So it was actually basically said that due to insider dealing, that's why Uchumi actually went under. So major investors in that particular company simply sold off most of their shares and actually left the company. So it ended up actually dwindling. So after that, basically when now they came up with the Capital Markets Authority Act to prohibit what we call insider dealing. And actually basically here in Kenya, it still actually happens because the laws are actually not basically being followed seriously. But if you go to foreign countries, like let's say, for example, the United Kingdom, it is a very serious offense to be involved in what we call insider dealing or basically insider trading. And basically the fines there are actually basically a bit so high, even compared to here in Kenya. So even that for that 1.5 or 2.5, you might find a business mogul will just pay out the amount. So they don't even care. But if you go to foreign countries like the United Kingdom, there are very serious laws with regard to insider dealing or insider trading. If you are found to be involved in such, it is actually a very serious offense. It is a serious offense. So we have what we call register of directors. So I think up to this particular point, we've come across several registers. For example, we've seen we can have a register of members, register of debenture holders. So we can also have a register of directors, a register of directors. So what are the particulars that will basically be found in this particular register? So because it is a requirement that the company should actually maintain the register of directors at its registered office. So it is actually supposed to maintain what we call a register of directors at its registered office. So what are the particulars? So it is a requirement that the company maintains a register of directors at its registered office, at its registered office, at its registered office. It is a requirement the company maintains a register of directors at its registered office. So what are the particulars? Particulars that will be found in this particular register. What are the particulars? So you can have, for example, names of past and present directors, past and present directors, past and present directors, the address of the directors, the address of the directors, the address of the directors, date of appointment, date of appointment, and vacation of office, and vacation of office of this particular director. What will also be contained there is other directorships in other companies, other directorships in other companies, other directorships in other companies will actually also be contained there. So other directorships in other companies, we've said names of past and present directors, the address of the directors, date of appointments, when was he actually appointed, and vacation of office, when did he actually vacate office, you can be able to tell. Other directorships in other companies, so you might find that a person is a director at Safaricom. If you go to Kengen, is actually also a director. So those details should actually be captured in each and every company's register of directors. So it doesn't mean that when you're a director in one company, you can't be in another company. So you find that people are actually directors in several companies. So other directorships in other companies. So we can also be able to have the qualification shares. The qualification shares held by the director. Qualification shares held by the director. The qualification shares held by the director. The qualification shares held by the director. So another thing to be able to know is that this particular register will be open for inspection to the members of the company during the working hours of the company for free. So you can be able to basically walk there and basically ask, you want to inspect that particular register or know more details about the directors of that particular company at the registered office, because you are saying that's where basically it is actually maintained. So for you as a member of the company, it is actually for free during business hours or working hours of the company. But if it is actually any other third party, that fee could actually be set as to how much you can actually be able to pay so that you can actually be able to inspect this particular register. So for members, it is for free during the business hours of the company or the working hours of the company. For any other person or any other person who wants to inspect it, a fee can actually be set. It won't actually be for free. So there's a fee set so that you can be able to inspect this particular register as per the requirements of the articles of association of that particular company. So that is the end of this particular topic, known as the topic of directors. So I would like us to start the next topic, which is the company secretary. The company secretary, another senior officer of the company. Another senior officer of the company.
A question.
Yes, you can ask.
Have we covered in circumstances under which a director will be personally liable? Liability of directors.
Liability of directors. You want us to look at that? Huh?
Because I came across a certain question.
You came across a certain question. So we can look at it. You can look at it. No problem. Just give me a minute. We're going to look at it.
Okay, thank you.
So the company secretary. So under the company secretary, you need to understand who is a company secretary, who is a company secretary, who is a company secretary, who is a company secretary. Another thing to be able to know about in this particular topic is the appointments and qualifications, appointment and qualifications of a company secretary, appointment and qualifications of a company secretary. Then disqualification from office, disqualification from office, disqualification from office. Then the duties of a company secretary, duties of a company secretary, duties of a company secretary. Then the last thing, the legal position of a company secretary, the legal position of a company secretary. So here, the legal position of a company secretary. So here we'll basically look at the company secretary as an officer of the company, as an officer of the company, as an agent, as also a servant, a servant in the company. So what do we mean by a company secretary? So this is actually a very senior officer in the company. So a company secretary is simply a person. A company secretary is simply a person. Who advises the company, or basically gives guidelines as to what are the requirements, in terms of how the company should actually be able to operate. What are the requirements, for example, under the statutes, with regard to operations of a company. So he's a person who simply advises or actually ensures the company is operating as per the requirements of the statute, or basically the regulations actually regulating operations of companies are actually being followed by the company. So he'll simply advise the board of directors as to basically how they're supposed to manage the company according to the requirements of the statute, or according to the requirements of the law. So what we mean by the statute, it is simply the Companies Act, because the company should actually operate within those particular confines, or basically laws set out in the Companies Act, not to basically go off the requirements under the law as to how a company should actually be able to operate. So the person who will actually be able to ensure this, that the company is actually operating as per the requirements of the law, is actually the company secretary. And most of the time, this particular company secretary will sit on the board of directors. So that's where basically be providing the advice to the directors that basically, if you are making this particular decision, is basically as per the requirements of the law, or is basically within the requirements of the statute, because the company should actually be able to go off those particular requirements. For example, if the company is to get particular licenses before they continue to operate, is the person to be able to advise the board that before you continue to operate in this particular industry, or maybe this particular area, there's a license you are supposed to get under the law. So once he does that, then basically the company is actually able to conform to the requirements of the law. So what do we mean by a company secretary? So you can simply be able to just say it is a person who advises the company. It is a person who advises the company on the requirements of the law, or statutes, with regard to its operations, Then you can be able to say also, after the full stop, he will advise the board of directors. On good corporate governance, on good corporate governance, how they're supposed to carry themselves as directors of the company. He will advise the board of directors on good corporate governance, and the regulations and the regulations and the regulations and the regulations under the statute and the regulations under the statute and the regulations under the statute. So that is basically what we mean by a company secretary. So another thing to be able to know is that for public companies, the point to go home, for public companies, the point to go home, for public companies, it is mandatory for them to have a company secretary. For public companies, it is mandatory for them to have a company secretary. For private companies, it's actually optional. It is actually optional unless the private company has a paid up capital of more than 5 million. So what have we said? For public companies or listed companies on the stock exchange, it is mandatory that they ensure they have appointed a company secretary. For private companies, it is not mandatory. It is actually optional unless maybe this particular company has a paid up capital of more than 5 million. So that is basically the requirement under the statute. If you go to the Companies Act, it is a requirement that if a company is a public company, it is mandatory that this particular person known as a company secretary is actually appointed. For private companies, it is actually optional unless the private company has a paid up capital of more than 5 million. That's basically when they can actually be able to appoint a company secretary. They can actually be able to appoint a company secretary. So another point is that if the company has, they can be able to choose. They can have either one or maybe two. So they can have even have two company secretaries. So depending on basically the work or basically the workload, they can be able to have maybe one or two. So if they're actually two, they'll be known as joint company secretaries. They'll be known as joint company secretaries. So if the company has more than one company secretary, they'll be known as, or basically they'll be termed as being the joint company secretaries of the company, the joint company secretaries of the company. So another point that you should actually be able to get, they are just up there. We've said, for a private company, it is actually optional for them to have a company secretary. So what actually happens in this case, for example, if there's anything addressed to the company secretary of a private company that doesn't have a company secretary, in such a case, it will be assumed that that particular item that has been addressed to that particular company secretary, it is being addressed to, for example, the directors, or maybe the company itself, or maybe any person appointed to act or serve in that particular role as a company secretary, or basically to act or basically serve as a company secretary. The duties he carries out in the company, they seem to be like that, those of a company secretary. So if the private company doesn't have a company secretary, let's assume there's a letter that has been addressed to the company secretary of that particular private company. It will basically be concluded that the person to basically receive such communication is actually the director of the company, or maybe it is actually just the company itself. You can just say the company itself, or basically you can actually be able to say, in this case, any person who has been appointed to basically undertake the duties or the roles of a company secretary in that particular company, even though he's not actually officially appointed as a company secretary. Because they could ask in the exam, what will actually happen in case of a private company that doesn't actually have a company secretary? If there's anything that is actually addressed, or there's any item that is being addressed to the company secretary of a private company, that doesn't have a company secretary, it will be assumed this item has been addressed to, number one, the directors, number two, any person who has actually been appointed to serve as a company secretary, number three, just the company itself. So any person will basically take over once it has actually been dropped at the company's premises is the one basically who will actually be able to handle such a matter. So appointments and qualifications. What are the qualifications before you can actually be appointed to be a company secretary? Appointments and qualifications. Yes, you have a question.
Yeah.
Yes.
Kindly, could you pardon for me that part of private company which doesn't have a secretary? I didn't get it.
If a private company doesn't have a company secretary, any item addressed to that particular company, any item addressed to the company, it will be assumed it has been addressed to semicolon, number 1, the directors, number 2, any person who has been appointed to act as a company secretary, number 3, the company itself. If a private company doesn't have a company secretary, any item addressed to that company, it will be assumed it has been addressed to, number 1, the directors of the company, number 2, any person appointed to serve or basically act as a company secretary or undertake the duties of a company secretary, number 3, the company itself. So we can look at appointments and qualifications of a company secretary. Appointments and qualifications of a company secretary. So the company secretary, so this is the first point that should actually go home. The company secretary will be appointed by the board of directors. So those who have the rightful mandate to appoint a company secretary in the company is the board of directors. So they'll simply actually be able to set out his duties and actually roles. So the company secretary of a company will be appointed by the board of directors. So those are the persons who actually appoint a company secretary in a company. So they'll set out what will be his mandate or basically duties in a company. So that is the first point that should actually go home, that the company secretary of a company will be appointed by the board of directors. So before this particular person is actually appointed to be the company secretary, what are the things that these particular directors will actually be able to look at? So number 1, they'll be able to ascertain, so the qualifications. So what are the qualifications? So the appointment, you've already said, it is by the board of directors. So that is the appointment. Then,
hello.
Yes, you have a question.
Yes, I have a question in terms of, I'm saying you are referring to board of directors.
Yes.
How many board of directors is a company required to have? Do we have like a minimum?
The minimum number of directors?
Yes.
For a private company, it is a requirement under the law that it must have at least 1 director. For a public company, it is a requirement it has at least 2 directors.
Okay.
Yes.
Thank you.
So what are the qualifications they'll be able to look at? So they'll be able to ascertain that the person, so number 1, the qualifications, the person has the relevant knowledge and experience, the person has the relevant knowledge and experience to serve as a company secretary, The person has the relevant knowledge and experience to serve as a company secretary. Number 2, another thing that the person is registered as a practicing company secretary. The person is registered as a practicing company secretary, under the Certified Public Secretaries Act. So that person should actually be registered to have a practicing certificate, or basically has been allowed to practice as a company secretary. So the person is registered as a practicing company secretary under the Certified Public, I've written it in short, the Certified Public Secretaries Act. So the person is registered as a practicing company secretary under the Certified Public Secretaries Act. So they'll be able to ascertain that this person, they look at basically the CV. So he has the experience, he has served as a company secretary somewhere else. So he has the expertise, he has actually basically interacted with several board of directors. He has actually been providing a lot of advice to several companies. So there's that experience. Number 2, they have to also ascertain that he has the practicing certificate. So he has actually basically been allowed to practice as a company secretary before they actually basically appoint him to basically be the company secretary. So I've just remembered, so there's something I had actually not actually mentioned here that should actually go home as to who is a company secretary. Another point to go home here as to who is a company secretary is that the company secretary of a company can either be an individual or a corporate body. So that is what you should actually be able to know about a company secretary, that the company secretary of a company can actually be an individual just like me and you, or it can be a corporate body. What do you mean by a corporate body? It is a registered firm or a registered company that basically provides company secretarial services to other companies, or you can just be an individual providing such services, or the company can actually be able to opt to have an in-house company secretary who has actually been appointed. So he's actually basically there like full-time to be the company secretary. Alternatively, what the company could actually be able to do, they could outsource or basically look for a registered firm of company secretaries to provide that service of a company secretary. So what should actually go home here also, very key points, that the company secretary of a company can be an individual or a corporate body, So it can be a partnership, it can actually be a registered company that basically provides those services of company secretaries to other companies, So that is a point to go home also here. So those are basically the qualifications they'll actually be able to look at before they actually appoint a person to basically be a company secretary, secretary. So we've said here that the person should actually be a registered person registered to be practicing as a company secretary. So what are the qualifications they look at before they can actually be able to allow you to practice as a company secretary? So the qualifications for being registered as a company secretary, so that is maybe a subheading you can write, the qualifications for a person to be registered or basically to be registered as a practicing company secretary are, so the qualifications for a person to be registered as a practicing company secretary are, so the qualifications for a person to be registered as a practicing company secretary are, so under this particular act, what are the qualifications they need to look at? So the most key one that is actually very relevant, so the person must have attained, so the person must have attained a final certificate from CASNEB for the CS examination, So there is another course in CASNEB known as Certified Secretary. So if you undertake that particular course up to the final level, so you basically get a certificate from CASNEB, and of course, with some relevant experience, you can actually be able to present it to the Institute of Certified Public Secretaries of Kenya. Then, of course, they can register you to practice as a company secretary, So apart from this particular qualification, they could look at any other relevant qualification. So any other relevant qualification, any other relevant qualification approved or allowed, any other relevant qualification approved or allowed under the Certified Public Secretaries Act, approved or allowed under the Certified Public Secretaries Act. So you could be having any other qualification and maybe you have the relevant experience. So it's that particular institute to be able to assess your papers or maybe documents and see if it is a relevant qualification, then they can actually be able to allow you to practice as a company secretary. So maybe you have the relevant experience and you don't have this particular qualification. So they could assess it. And of course, if you basically qualify, they'll actually be able to give you the practicing certificate. But the major qualification is actually this one. It is actually this one, the CS exam with cast name up to the final level. So once you basically attain that particular certificate, then you can register and start practicing as a company secretary. And then, or in this case, it simply means you provide services of company secretary to several companies. So you can be able to be providing those particular services. So we can look at disqualification from office. So under what circumstances can this particular company secretary be disqualified from office? Disqualification from office. Disqualification from office. Disqualification from office. So under what circumstances can this particular person you are calling the company secretary be disqualified from office? Can be disqualified from office. So the circumstances under which a company secretary can be disqualified are, so the circumstances under which a company secretary can be disqualified from office are number one, if found to be involved in fraud or dishonesty by a competent court, or just say by the courts, if found to be involved in fraud or dishonesty by the court. Number two, if the company secretary is found to be insane, also if the company secretary is declared to be insane, or of unsound mind by a qualified medical practitioner, by a qualified medical practitioner, Number three, if he is undischarged bankrupt, or declared to be bankrupt. So these are some of the reasons that basically will make a company secretary to be disqualified from office, or basically you can be able to say here, if he makes any compromises or arrangements with his creditors. So what we mean by these, creditors are actually all over him. So they want to recover all the liabilities or all the debts from this particular person we are calling the company secretary. So he has to basically clear off his name with those particular creditors before he can actually continue to serve as the company secretary, So these are some of the reasons that can actually be able to make a company secretary be disqualified from office, Then the other thing is that what we can be able to say about the company secretary is that this person you are calling the company secretary, some people just assume is like just that normal secretary they send to take papers, to do typing here and there in the office. No, that is not what we mean by the company secretary in this case. The company secretary in this case is actually a very senior officer of the company. So gone are the days basically whereby the company secretary was just basically like a puppet of the board of directors. So long time ago, this person was just seen like, for example, the puppet of the board of directors, because they're the ones who actually appointed him. So they set out what will be his duties or roles. So nowadays, what has actually happened, this particular person you are calling the company secretary has been given a lot of mandates or duties or powers under the statute or under the Companies Act. So some of the roles he actually plays in the company are actually very major. And of course, this is actually a very senior officer of the company. That's what we are saying. Basically, he even actually sits on the board of directors and actually advises the board on matters concerning the law with regard to how the company should actually be able to operate. So previously, long time ago, so maybe like in the early 19th century, this company secretary was just seen like, for example, a puppet of the board, or basically just to act as an agent of the company in certain matters, for example, acquiring things like, for example, office furniture. So gone are those days. Nowadays, the company secretary is actually empowered under the statute. If you look at the Companies Act, you'll basically be able to realize that this person actually plays a major role in the company. So he's actually usually a very senior officer of the company. And of course, for company secretaries for big companies, if you look at, for example, their pay, so they're usually paid heftily. So they're paid a lot of money. So he's not a very junior officer in the company. He's actually a very senior officer in the company. So because he has actually been empowered, he has a lot of duties as outlined under the Companies Act, which you are just going to be able to look at. And of course, that is actually what we now want to look at. What are the duties of a company secretary? The duties of a company secretary. The duties of a company secretary. Duties of a company secretary. Duties of a company. Duties of a company secretary. The 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 duties of a company secretary.
Hello, Mwalimu.
Yes.
I have a question.
Yes, you can ask.
Most of the companies I see, it's like most of the lawyers are the ones who are the company secretaries.
Yes.
Do they need to have the qualification of having qualified as through the certified public secretaries?
Okay.
Or any lawyer can become a company secretary?
Okay, it is important that that particular aspect of law is actually very important, is important because as you've gotten from my definition, I've said that he'll basically advise the company as with regard to regulations as to how the company should actually be able to operate as per the requirements of the law. For example, in this case, this person who is basically advising the board should actually be able to understand, for example, the Companies Act very properly, or basically how meetings of the company should actually be carried out under the law, or anything to do with the company, how it is actually supposed to be carried out. So he should actually be able to understand the law very, very properly. And if you look at basically, as I've said, when this person is actually going to seek for that particular practicing certificate, I've said they look at, apart from that particular CS final, they can look at any other relevant experience or basically relevant qualification to be able to allow him to practice as a company secretary. So long time ago, before this particular, there were proper laws with regard to the issues to do with company secretaries. Even before the Institute of Certified Public Secretaries was actually set up, actually lawyers were actually allowed to be able to practice as company secretaries, or basically provide company secretarial services. But of course, after the law was actually basically enacted, this particular act, the Certified Public Secretaries Act, it simply meant that the major qualification so that you can actually be able to practice as a company secretary was actually the CS exam up to the final level with CASNEB. But of course, as I've said, they could look at any other relevant qualification. Maybe you have the experience or expertise or knowledge. You've been practicing as a company secretary before this particular law came into effect. In such a case, they'll actually be able to allow you to be able to maybe practice or provide company secretarial services. But for the modern lawyers, so basically those who are actually basically acquiring law degrees currently, before you basically proceed to actually basically practice as a company secretary, that CS exam up to final level is very important. So that's why you'll find that most people actually undertake that particular qualification. Most of them, they are usually lawyers. So they have done the law degree, LLB, up to the final level, but now they are basically seeking to be able to serve as company secretaries in other, in companies. So they'll be forced to basically go to CASNEB, register for this particular exam, and actually do it up to the final level. So that one does not actually limit you, for example, you as a CPA, after you finish your CPA to do this particular exam and you practice as a company secretary, you'll basically have the right qualification. You'll be able to match with even that particular lawyer to provide those particular company secretarial services, because it is not actually only advising on matters to do with the law. There are several other duties that are actually normally carried out by a company secretary. And for you, basically a person who has actually done this particular exam, those papers you undertake in this particular qualification, they are quite relevant to you. You get the required knowledge to be able to advise the board on matters to do with how the company should actually be managed. Because if you do, for example, this particular qualification, CS, company law is actually one of the papers there. And of course, under company law, you as a student, you've actually been able to discover a lot about companies, how they are supposed to be managed. So apart from company law, there are other papers under CS exam, which are actually basically very relevant to give you more knowledge and actually expertise as to how companies should actually be carried out. Or basically companies should actually be run according to the requirements of the law. So if you go to the advanced level, for example, you learn things to do with, for example, corporate governance, human resource management, governance. So things like those ones, which are actually basically relevant for you to be able to advise the board, because you sit on the board of directors as a company secretary. So you can advise them on matters to do with corporate governance, how they're supposed to carry out themselves as directors of the company. What is their expectations as directors of the company? So those are the things that you should actually be able to provide or actually advise the board on, apart from just matters to do with the law. So that is what should actually be able to go. So most of the lawyers actually basically are company secretaries. But of course, as I've told you, the modern lawyer or the current lawyer, before he actually gets that particular practicing license, he actually must actually be able to do this particular exam with CASNEB up to the final level. But previously, before the law was actually enacted on how company secretaries are supposed to be regulated, that particular Act of Certified Public Secretaries Act came into effect. Previously, lawyers were actually basically fully qualified to practice as company secretaries. But the major qualification before you can actually be able to be appointed as a company secretary, it is simply the CS exam up to final level. So what you should actually be able to gather here is that once you've done CPA up to final level, You can simply go the other side and do actually CS up to the final level. And of course, once you set up your firm as maybe an auditor, you can actually also provide company secretarial services. So that is the major qualification. So once you get it, it won't limit you if you're not a lawyer. In fact, you might actually be the best person to serve as a company secretary because you would have known more about how companies are supposed to be run. And of course, when you look at the duties, you'll actually be able to realize it's not only matters to do with the law. So there are things to do with, for example, shares, how shares are supposed to be distributed in the company. You're the one to advise the company in such matters. Approval of transfer of shares, you're the one who's actually basically going to advise the board. Matters to do with, for example, payment of dividends, you're the one basically who's supposed to maybe issue out the dividend vouchers. So that is basically knowledge that you as a person who has just done that particular qualification, you can actually be able to provide such kind of services. But as you've said, you realize that most of the lawyers or most of the company secretaries for big companies are usually lawyers. But of course, you'll find that, for example, those people who basically work under those lawyers have majorly done the CS exam up to the final level. So both of them can actually be able to match to be able to provide the company secretarial services, because that is basically the relevant qualification that is actually known or recognized by the Institute of Certified Public Secretaries, the CS exam up to final level. It's just like, for example, you as an accountant, the most relevant qualification recognized by ISPAC is actually basically CPA exam up to final level. So even if you don't have that particular degree, it won't limit you basically to practice as an accountant. So long as you've done your CPA up to final level, you can fully basically practice as an accountant and actually provide basically consultant services with matters to do with auditing to several companies.
Okay, thank you.
Molim, I have a question.
Yes.
After completing CPA and I want to do CPS, will I get any exemptions from CASNEB, or I'll just start it from intermediate level?
No, you'll get exemptions. You'll get exemptions. There are common papers that you've already done. For example, company law, you won't do it. They'll exempt you because it is in CS and also it is actually in CPS. So they'll exempt you all the papers you've actually been able to do. So you'll start probably from utaanzia hapo chini, hii level ya kwanza, utaanzia hii level ya pili, then utafanya ya tatu. Hiyo level ya tatu utafanya like almost all the papers. Apart from there's this paper, I think leadership and management, you won't do it because it is actually in CPA and also it is actually in CS. So that one they'll exempt you. But all the other 5 papers, you'll be able to do them at the advanced level.
Okay.
So we can look at the duties of the company secretary, So the first duty that you can actually be able to note, so this one is actually usually very common in this. They like testing it. It has been tested like almost 5 times. If you go through the past papers, you'll come across this particular question. It is very common. They like testing the duties of company secretaries, So you can simply be able to say, so the duties, so the first one, to ensure that all the registers of the company are up to date, So all registers of the company are up to date. To ensure all the registers of the company, are up to date. To ensure all the registers of the company are up to date. Then to ensure the safe custody and correct use of the company still, to ensure the safe custody and correct use the safe custody and correct use of the company seal, to ensure the safe custody and correct use of the company seal. To ensure the annual returns to the registrar are accurate and submitted on time. To ensure the annual returns to the registrar are accurate and submitted on time, to ensure the annual returns to the registrar are accurate and submitted on time. The next one, the next duty, to ensure the company complies, to ensure the company complies with the Companies Act, articles and memorandum of association. To ensure the company complies with the Companies Act, articles and memorandum of association. The next one, if it is a public company, if it's a public company, if it is a public company, ensure it complies with the securities exchange requirements. It complies with the securities exchange requirements. With the securities exchange requirements. If it is a public company, ensure it complies with the securities exchange requirements. So the Nairobi Securities Exchange. So there are certain requirements that you're supposed to meet once you are listed as a company. So maybe you should have at least a particular number of directors. You should have at least a particular minimum share capital. So before you can actually be listed to be on the securities exchange. So the company secretary is actually the one to ensure such has actually been followed. Then to ensure changes in membership, So another point, to ensure changes in membership, are handled, correctly. To ensure changes in membership are handled correctly. Another point, to attend companies meetings, and record and maintain the minutes. To attend companies meetings, to record and maintain the minutes. To attend companies meetings, to attend companies meetings, and record, to attend companies meetings, to record and maintain the minutes, the minutes and maintain the minutes. To attend companies' meetings, to record and maintain the minutes. Our point is to ensure the company's dividends, to ensure the company's dividends are paid correctly, by sending out valid dividend vouchers to the members. By sending out valid dividend vouchers to the members. Another point you can be able to add is to ensure the annual accounts, are sent out to the members, to ensure the annual accounts are sent out to the members, or shareholders, to ensure the annual accounts are sent out to the members or shareholders and the registrar of companies. So those are the duties of a company secretary. So there's a point I've mentioned there, that to ensure the annual returns are actually submitted to the register of companies each and every year. So what you need to know there, that apart from these normal returns, for taxes that are normally submitted to the Kenya Revenue Authority, there's another return that is normally submitted to the register of companies each and every year. So if you fail to basically submit that particular return, you will actually be penalized. So there's usually a penalty. I think it's around 1,500 per year. So if you fail, you're supposed to pay that particular penalty. So the person who prepares that return, it is normally the company secretary. So without the company secretary having to basically stamp or approve, it cannot be accepted. It cannot be accepted by the registrar of companies. So that stamp for, or that seal for any company secretary is actually very important on that particular return. So they're the ones who are supposed to actually prepare it and actually submit to the register of companies. So it will only be accepted if it has actually basically been prepared by a company secretary. So that is basically how, for example, they're actually able to make their money. So because they know each and every year companies will basically come to them to basically seek for their guidance on basically preparing the returns and submitting them. Because without that stamp of a registered company secretary, the return won't be accepted by the register of companies. So at the registrar's office, they'll be able to ascertain or look at the list of all the registered company secretaries. Is this particular person who has actually basically approved this particular return a registered company secretary? If it is not, it simply means that the return won't actually be successful. So that is part of their duty. So they keep the company sales safe. So they are the ones who are supposed to ensure the company sale is actually safe. It is not actually being misused. They send out dividend vouchers or dividend mandates to the members of the company once dividends has actually been declared. So they're the ones who are supposed to prepare the vouchers and send them out as to how much a member will receive as dividends. They also handle matters to do with the change of membership, for example, transfer of shares and change of membership in the company, or maybe there is a transmission of shares for change of membership in a company. So they're the ones who are supposed to handle such kind of matters before they actually approved by the board. So they also advise the board on matters to do with the Companies Act or regulations guiding that particular company in the industry it is actually operating in. What are the laws the company should actually be able to conform with? So they're the ones who are supposed to be able to advise the company on such, and of course, ensure the company is actually basically operating as per the requirements of the rules governing the internal affairs. So that is the articles of association. So those are part of the duties or the roles of the company secretary, part of the duties or roles of the company secretary that should actually be carried out. So we also talked about taking of minutes at the meetings of the company. So they are the ones who are supposed to take those particular minutes, ensure the minutes have actually been recorded or actually are on record for each and every meeting of the company, the general meeting, the AGM. So the important meetings of the company, they're the ones who are supposed to attend and actually maintain those minutes maybe on a file. So if reference is to be made, they're the ones who can actually be able to provide such kind of minutes. So those are the duties of the company secretary. Those are the duties of the company secretary. The duties of the company secretary. So I think we can end there. So next time we'll wind up with the legal position of the company secretary and start the next topic, which is actually accounts. I think accounts and audit. I think accounts or something. Accounts and audits. Then we'll look at, we'll combine it. We'll do like 2 topics in the next class because they are not that long. We might do just both of them. So accounts, then we'll look at investigations, company investigations, which is actually also very short, So that will be topic number 10 and 11, topic number 10 and 11. But maybe before that, we'll look at a few questions here about directors and the company secretary so that you can be able to see how they are normally testing in the exam. But I would wish to end the class there. So unless there's a question or a burning question, you can ask. So there's that particular aspect of criminal liability of directors. So I think I look at it next time. Maybe when we'll be tackling or answering the questions, I look at that particular bit of criminal liability or how the directors can be held criminally liable, under what acts, or what if they have done what they can actually be held criminally liable in the company, So unless there's a question, you can ask now, but I would wish to end the class there. So if there's no question, you guys can have a good evening. We'll meet next time. So that will be, I think is it Wednesday? We'll meet on Wednesday from around 8 p.m.